First debate of the afternoon is legal aid. Dr. Julian Huppert.
Thank you, Mr. Weir. I hope this is a very timely opportunity for us to debate the issue of legal aid, a vitally important component of our legal system. Opportune because although the government consultation, a consultation that received around 5,000 responses, has closed, the government hasn't yet published a response. There's therefore, I hope, still a chance for the government to listen to concerns from all around the House before it provides its final recommendations. And I'm delighted to welcome the Minister here to respond to the debate, and more particularly to listen to it. He and I spent some time in debate in 2005. While I didn't always agree with his positions on everything, he did show then that he would listen to an argument, and I hope he'll show the same character today. One of the basic pillars of our legal system is supposed to be that the law is accessible to all, not just those who can afford it. And in another committee, we're seeking to reform the law of libel, to ensure that success goes to those who have truth on their side, not those with the most money. And here we discuss legal aid, the manner in which we ensure that all have a fair chance to access the law and to see justice done. Now, the government has been at pains to emphasise its commitment to access to justice, and we would all, I hope, agree with the government's stated position that access to justice is a hallmark of a civil society. Many of us would go slightly further and say it's a hallmark of a civilised society. Now, the Green Paper that announced these proposals suggested that the Ministry of Justice believes that legal aid has expanded far beyond its original intentions. Now, I recognise, of course, there is often waste, and that there are unnecessary costs that can be eliminated or reduced. We should avoid simply caricaturing the current legal aid system. In my opinion, the legal aid system as it currently stands actually seems to represent broadly what Lord Rushcliffe had intended in his 1945 report. He argued that public funding for legal aid should not be limited to those normally classed as poor, but should also include those of small or moderate means. Now, according to the Ministry of Justice, the current legal aid system makes 29% of us eligible for publicly funded advice. One could argue, in fact, whether that goes far enough. Given the very unequal income distribution we have, even the median wage could well be described as falling under small or moderate means in some parts of the country. Now, I do accept that the wider fiscal situation and the rapidly growing nature of the legal aid budget both allow room for a consolidation through reductions in the budget. There is a balance to strike between access and cost. And this debate is largely an opportunity to discuss how such reductions can be achieved without harming the most vulnerable people in our society. A large portion of my speech will therefore deal with the scope of the government's proposals, but I also hope to draw the Minister's attention to the viable alternatives that have been proposed. Given the number of honourable members from all around the chamber here for this debate, I will try to be somewhat brief to allow others to speak. I'm sure one could easily fill 90 minutes with more detailed analyses of every single issue that I will cover. And it's easy to forget the recent history of legal aid, but I think it's important to look at some context for this afternoon's debate and remind ourselves that it underwent substantial changes under the previous government. Labour launched something like 30 consultations and reviews to try to sort the system out. And since the coalition has been formed, there's been the McGee review of legal aid delivery and governance and the Family Justice Review chaired by David Norgrove, both of which are pertinent to this debate. And I have to say that I'm very glad that the government eventually delayed its response to the consultation on legal aid until after the interim report of the Norgrove Review was produced. It's always useful to get expert advice before making decisions. And please be in no doubt, I appreciate much of what the Ministry of Justice has done since the coalition was formed. In general, I admire the liberal proposals on sentencing and other areas stemming from the Secretary of State and his team of ministers, though they may not thank me for that praise for their liberalism. And it has been particularly good to see a renewed emphasis on evidence and on justice reinvestment, taking us away from the obsession with prisons and punishment and renewing our desire to see criminals rehabilitated. We want less crime, not just to be harsh on the criminals after the event. But there are problems with the government's proposals, many of which will be familiar to the honourable members who have been following this debate. And honourable members will also want to familiarise themselves, if they haven't done so already, with the excellent report from the Justice Select Committee, chaired by my right honourable friend, the member for Berwick-upon-Tweed, the large majority of which I agree with. And I want to focus particularly on the effects of the proposals on access to advice on social welfare law, particularly with regard to immigration law, family law and children and young people. I will also highlight what I believe are the unintended consequences of the government's proposals on Citizens Advice Bureau and other organisations. But I think first it's worth questioning the central decision at the heart of the government's proposals. From the off, they considered it impossible to pare down any further expenditure on criminal legal aid. Like many others, I remain unconvinced that we should leave criminal aid, legal aid, entirely untouched when it accounts for more than half of the total budget, even if it has come for close attention previously. Now, obviously, I don't want to deny people access to justice in criminal trials, but I do believe there may be further scope for savings there. And I hope the Minister will heed that note of slight uncertainty and respond to it when he speaks on. But there are other areas where my uncertainty is more than slight. The main one of these is family law. And I have received many representations from organisations and individuals right across the spectrum, from those who need legal aid to those who provide it, and almost everything in between. And I cannot overemphasise the concerns these people have over the possible effects of the government's proposals. Time and time again, I've heard the same criticisms. The government has brought forward proposals without properly researching the effects of the current system, without adequately justifying their stance. And that as a result, the unintended consequences of the proposals, if implemented, could be regressive and widespread. Indeed.
I do thank my friend for giving way, and he's making a very strong case. Does he agree with me that there is a big danger that people in a whole host of vulnerable groups could really be disadvantaged in front of the law? Mental health, those suffering domestic abuse as opposed to domestic violence, rather more narrowly, learning disabilities, we can go on and on and on. Would it not be better to be raising the bar for legal aid, but actually looking at case by case?
Julian Huppert.
Thank you. I thank my old friend for her comments, and she raises a number of issues, some of which I will come on to talk about. And it's a challenge. There is no doubt about it. There's no easy solution that says that we can protect all of the vulnerable groups that we need to. But there are ideas, such as the one that she mentioned, such as the work the Law Society has done, which I think may provide a better option.
Would my honourable friend give way?
Indeed.
Whilst my honourable friend is making an excellent case, and congratulations on that, does he not agree that rather than this review being largely budget-driven, that it should at least begin with an understanding that legal justice is inextricably linked to social justice, and that the impact of many of the changes proposed by the government, particularly in the area of homelessness, for example, where it should be very narrowly defined at the time when government's own policies in homeless legislation, in housing benefit and other areas are going to create a very disruptive impact in that particular sector. Therefore, we need to have a legal aid system which is actually able and flexible enough to be able to assist those who are going to find themselves very much on the margins of society.
Julian Huppert.
Indeed, I thank my honourable friend for coming to the debate and making his extremely valuable points. And indeed, he's right that actually social justice does lie at the heart of so much of what is happening, and the lack of social justice that we see in this country, the widening disparity between the rich and the poor, which continued under the previous government and is a really sorry blight for all of us. And that affects so much of public policy. We know, for example, in the field of healthcare, that actually one of the worst things in health is the effects that social injustice and deprivation has on health. Actually, that's a much more fundamental problem that we need to solve than exactly what happens in an A&E hospital, and the same goes for the examples that he gave. But if I could now turn to the issue of family law, which is one that particularly concerns me. And I'm indebted to a number of people for drawing my attention to this. But in particular, I'd like to thank Joe Miles, a fellow in law at Trinity College in Cambridge, where I used to be a fellow, who's put a lot of effort to try to produce evidence-based assessments of the Green Paper's proposals. And I know that she has been in touch with ministers as well. Now, the Green Paper's reforms in the area of family law constitute a radical reduction in the scope of private family law issues for which legal aid is available. And the policy is based on two premises. And perhaps to say they're outright false is going too far, but they are questionable and not well justified. These premises are, firstly, that spending on legal aid fuels litigation, and secondly, that mediation is the clear alternative. Now, in some cases, there is no doubt that lawyers on each side, and I declare an interest as a non-lawyer, ramp up the cases in order to earn fees. And they make a tense situation worse for individuals, as well as expensive to the state, and, of course, to the side which doesn't have legal aid. But it's not clear that this is common or regular. And, in fact, it is very probably because clients are currently able to see a solicitor that litigation is avoided in many cases. Solicitors can play a very important role in guiding their clients towards agreed resolutions or advising they have too weak a case to fight. Without professional guidance, badly founded and badly prepared litigation conducted by the client in person will surely follow and grow. This will mean an inevitable, probably substantial rise in the number of litigants in person in the family courts and the costs associated. I have seen no evidence for the assumption that the government has there will be no significant impact on court operating costs. I strongly suspect that what is saved in legal aid may simply be spent in court costs. The result will be that, as ever, those who have money will have access to justice. Those who haven't the cash and also lack the energy and resources to litigate by themselves will simply not have access to justice. And those who have not been able to enforce the other party's private law responsibilities will have to fall back on the state for housing and other support, another cost to the Exchequer. So, in fact, the removal of public funding from these areas of family law may have the opposite effect to that which is intended on the finances. On a related note, it may also hamper successful mediation. Studies have shown that one of the main reasons why mediation has been successful has been the threat of potential litigation. This encourages people to adopt sensible positions and so to settle. Will it still work as well in the absence of this as a plausible threat?
Would my honourable friend give way?
Indeed.
Thank you. Thank you. I will declare an interest, if I may, in this debate, having been a legal aid family lawyer. Just picking up the point of mediation, does the honourable member agree that mediation actually can be quite useful, but it's no panacea, and it frequently fails, often when there's an imbalance of power, which is often the case in family matters. And it concerns me that the government's proposals do rely on mediation. And that my concern too is where are all these mediators going to come from and who is going to pay for them?
I thank the Honourable Lady for her comments and bow to her greater expertise in this particular area, and she's absolutely right. Mediation is fantastic. There is no doubt about that, but it does not solve every problem. It is a great thing to see where it works. Where it doesn't work, you have to have alternatives. And she raises the important point as well about the number of mediators. We're trying to turn to more and more mediation, more and more arbitration in a whole range of areas in the law, and there is a real question about how we can train people like that. So I hope that the government will revisit its proposals on reducing the scope of family law. We share the objective of controlling cost while preserving access to justice, and I hope the government will be able to reach a better balance than it did in its original proposals. But let me now turn to another element of family law which has had almost as much attention from the same organisations, the issue around domestic violence, which my honourable friend mentioned earlier. This is a blight that is far more common in our country than many of us would like to believe. It's a very private crime and so difficult to measure. But estimates based on available data, such as the British Crime Survey, suggest that as many as 1 in 5 adults have experienced it in some form. And the Green Paper takes a very narrow view of what domestic violence constitutes and how it can be evidenced. It seems that the government's only counting physical violence under the definition of domestic violence, and even then, only where relevant legal proceedings have been started or orders obtained in relation to it. And there are a couple of concerns about the consequences of this. Firstly, it provides a perverse incentive for people to allege domestic violence just to get access to funding for their other issues. In other words, it encourages court proceedings. It's not clear whether that would be actually people admitting what is actually happening or leading to false allegations, but either way, it will increase the court proceedings. Because we know there is a huge amount of research that many victims of domestic violence do not disclose their abuse at all. They're reluctant for all sorts of reasons to take legal proceedings in relation to them. We should not make it hard. And all of that would be bad enough. But I hope I need hardly convince anyone here that domestic violence surely cannot refer simply to physical violence. The threat of violence and mental torment must surely be something we would all be concerned about. I hope the government will take seriously the criticisms it has received on this point and clarify and strengthen their definition of domestic violence, that those who are at risk have access to justice and are protected. And there's a particular issue about those people, normally women, who are in the UK on a spousal visa with no access to public funds and are then subjected to domestic violence. And I've met such people myself in the Cambridge Women's Refuge, and I am delighted that the government is taking some steps to support them, extending the funding for the Sojourner project, for example, which I hope will continue even longer. Everyone will work together to help these people. There'll be legal aid funding for them to get an injunction against their ex-partner. UKBA will fast-track their visa application, but there won't be any support for them to actually apply for the visa that unlocks all of the rest of their future support. Surely that is not right. And women in general will be disproportionately affected by the changes in legal aid. They are more often the recipients and less often have their own finances in place. Children and young people will also be disproportionately affected, partly because women make up the majority of primary caregivers, although of course not all. And I've received a considerable amount of evidence from a number of organisations suggesting that these proposals could deny many thousands of children and young people access to justice. Now, the Lib Dem youth policy includes a commitment to providing young people with access to specialist support and advice on their legal rights and responsibilities, something I would hope would get universal support. And I therefore would urge the government to think again more carefully about their proposals for young people. This seems to me clearly a group of people who are in general vulnerable and less able to represent themselves. It seems to me then that the current scope of legal aid should remain available to children and young people, even if it has to be reduced somewhat for adults. We should also be trying to target funding and support better towards this demographic in the future. And similar concerns apply with disabled people, whether they're young or old. The government plans, for example, to remove legal aid where it relates to matters of special educational need. Now, the Green Paper sought to justify this because they're an alternative source of support. They don't consider parents and carers bringing SEN appeals to be particularly vulnerable, and they believe that education of children should not get the same level of priority as other more critical issues. And I think this last is most concerning. The coalition government has taken some good steps to support families with disabled children. For example, the SEN Green Paper for my honourable friend, the member for Brent Central, which is a great step forwards. But this change would send entirely the wrong message to those families. Access to children is a right for education is a right for all children. It is a vital mechanism for removing some of the barriers facing disabled children and young people.
Well, thank you.
Indeed.
I'm very grateful to him. And on that very point about special educational needs, would he not further welcome the proposals in the Green Paper to move to a system of mediation to resolve a lot of problems that parents and children have in challenging decisions made by local authorities? And should not that system of mediation be put in train with any changes to legal aid so that we do not end up in a situation where the good intentions of the Green Paper are frustrated by a lack of coordination between two departments?
Julian Huppert.
I thank the honourable gentleman for his comments. And yes, again, mediation can play a good role. And there are a number of cases where we do need to move away from the legalistic approach to resolving some of these problems to mediatory type approaches. But again, as I said earlier to the honourable lady, they don't always work. Where do we get them all from? We have to make sure that there is a fallback, a safety net for these people. I can't deal with all of the issues about this area. I assume the government has seen the briefings from the Children's Society and the Special Educational Consortium, and I hope the government will look at those. I'm sure other members have seen them as well. But indeed.
Andrew George.
I'm grateful to my honourable friend, and he's been very patient in allowing me. With regard to the theme which underlies this, which is public service and the improvement of public service, actually there is an important link which mustn't be lost by the government in terms of ensuring that those people who are there who are seeking to benefit from those public services should see an improvement in them. And we found this in the Health Select Committee. We look at clinical negligence, and that where, for example, the removal of legal aid is proposed in that area, how can a service move on and improve and learn lessons if those who are served poorly by that do not have access to the right kind of justice?
Julian Huppert.
My honourable friend makes an excellent point. I'm hoping to talk a bit later about the effect of the Jackson changes and how legal aid will work there and this double whammy that may happen to people with the two changes rolled up together. Lastly, on the subject of special educational needs, I'm sure other honourable members have had the constituents coming to see them as I have. And my constituents take special educational needs appeals for their children very seriously. They are very concerned. I've had a number of people coming to see me. They are terrified, both about what happens for their own children and about the future. They see education for their child as absolutely critical for the future of that child. Now, I could talk about other areas, but time is moving apace. There are other areas I wish to discuss. And the next thing I'd like to raise is the issue of immigration law. And honourable members may be aware I have a passionate interest in issues around immigration and asylum, and I chair the all-party parliamentary group on refugees, as well as being a member of the Home Affairs Select Committee. It's a great pleasure to see the chair in his place. And if I could now talk about the proposals about immigration law. Now, I'm, of course, very pleased that asylum will remain within the scope of legal aid, but it's extremely concerning that other immigration cases have been excluded. Even under existing arrangements, immigration legal aid providers are struggling to remain viable. If we confine legal aid just to asylum, then it is doubtful whether good quality practitioners will continue to be available in this area. And I have to say there is already a surfeit of poor quality lawyers and advisors working in this field. We would all benefit from better provision being available because many of those people are simply not up to scratch. Indeed.
And congratulate him on this debate. Is he aware that there are many legal aid practitioners who were dealing largely with immigration matters in inner London have now gone under? And if one goes to any immigration appeal tribunal hearings, which I frequently do and represent people at them, there are a disturbing number of very strong claimants, very strong cases that go completely unrepresented, and as a result, all kinds of family breakup and misery results from this. It's not a great deal of money to invest in getting a reasonable access to justice for some of the most vulnerable people.
I thank the honourable gentleman for his comments, and he is absolutely right. I'm not an expert on the position in London itself. I know the position around Cambridge, and there is a shortage of good people, and I see that with my constituents time and time again. Indeed.
I'm most grateful to the honourable gentleman for the work that he does as chair of the All-Party Refugee Group and indeed on the Select Committee. Further to the point made by the honourable member for Islington North, one of the problems is if the specialism disappears, and there are specialist legal aid lawyers dealing with immigration, then our constituents, who are very vulnerable in those circumstances, may go to unscrupulous immigration advisors, get charged huge amounts of money, and at the end of the day are left with absolutely no recourse except to come to us as members of Parliament, and we're not really qualified to give them that advice.
Julian Huppert.
Indeed. No, I thank the right honourable gentleman for his comments. I find it astonishing just how many constituents I see who have been advised poorly. I mean, it is shabby. The most extreme example was one lady who was applied through a lawyer, got leave to remain, went to renew her passport and discovered the whole thing was a forgery. We're still trying to resolve how to fix that one. We need good quality, decent lawyers, not rather shabby, disreputable people in that space. But actually the main point I wish to make here is actually about the approach of the UKBA, the border agency, in dealing with issues. And there is a well-known sticking point around their attitude. There is rarely scope with them for negotiation or mediation. And UKBA seems to take the view they'll stick to their decision until ordered by a court to change their mind, almost regardless of the evidence. And we've seen this in so many cases where applications for right to work from people have been ignored until UKBA was ordered to deal with them by higher courts. Many applications for refugee reunion that are refused are then overturned at appeal. And it seems that the appeal system is currently being used by UKBA as a safety net. Under the government's proposals, these cases would no longer be in scope for legal aid, and there would not be the opportunity to fix the errors that UKBA is making. And I want to urge the government to listen to practitioners representatives of asylum seekers and refugees. The government should ensure that asylum support remains in scope as a high priority, and should ensure that applications for family reunion should be treated as an extension to a claim for asylum and also to be in scope for legal aid purposes. Now, there are certainly cases where applicants with a poor case do abuse the system, looking for appeal after appeal in a fruitless quest for victory. But there are also those with a strong case who have to go through repeated hurdles to get justice. And actually the key solution is for UKBA to get more decisions right the first time, as the Immigration Minister has accepted when I raised it in the Chamber. Again, there's a lot more I could say on this point, but I want to give a brief example of the impact that the government's proposals may have on service providers, having spoken quite a lot about their effect on different vulnerable groups, and then I will allow other honourable members to speak. And I've had a lot of comment from a range of organisations and individuals who provide support. I wish I could talk to all of them, but let me just focus on the role of Citizens Advice Bureau, as I suspect all honourable members will appreciate the vital role they play in our constituencies, not least in preventing the flood of casework we all receive from becoming even more torrential. And Citizens Advice have produced detailed briefings showing the unintended consequences of the government's proposals on social welfare law work. Their cost-benefit analysis makes a very strong case for retaining and even strengthening their role. For instance, their research finds that for every pound of legal aid expenditure on housing advice, the state potentially saves £2.34. On debt advice, the state saves £2.98. On benefits, £8.80. And on employment advice, £7.13. With rather impressive understatement, Citizens Advice suggests that the Ministry of Justice gets a good return from expenditure on legal help in these areas. Now, they estimate that if funding were no longer available for these categories of law, at least £172 million additional costs would accrue for both state and society. And what effect would these proposals have on the CAB service more widely? Over half of the Bureau surveyed in December last year said the changes to legal aid scope and the reduction in fees would pose a real risk to the continuation of their local advice service as a whole. I'm sure I don't need to remind honourable members of the havoc that this would wreak in our communities, and the large amount of extra work that would almost certainly come our way as a result. And I would also, in passing, praise the excellent work by Rachel Talbot and the Cambridge Citizens Advice Bureau, who are always there to help me and my constituents. And also I'll praise Cambridge City Council, who managed last year to provide them with a 25% increase in their grant, and I wish all councils took such steps rather than pulling resources from such vital public services. Time is running short, but I wish to raise two more brief points. The first, as raised by my honourable friend earlier, concerns the effect of combining these legal aid proposals with the Jackson proposals in clinical negligence cases. Jackson was actually very clear and said, "I stress the vital necessity of making no further cutbacks in legal aid availability or eligibility. The maintenance of legal aid at no less than the present levels makes sound sense and is in the public interest." Will the government take account of this plea and avoid a double whammy from legal aid changes and the Jackson changes, meaning that those who have suffered through error would not be able to continue with their case? And lastly, let me flag up a concern raised with me by Andy McGowan, who is the Access and Funding Officer of Cambridge University Students' Union. He was one of those rare people on free school meals who got to Oxbridge, as the government would like to see more of, and he would like to practice as a criminal legal aid solicitor, driven by a motivation which I'm sure we would all endorse, to help the most vulnerable in society. He asks, how can he fund the legal practice course in the absence of the training contract grant scheme, knowing that he will be unlikely to be paid as well as those lawyers for whom money is the principal motivation? If we lose people like Andy from the profession and public service, we are creating a less fair future for many years to come. It's not my intention to simply attack the government's proposals without offering an alternative. I don't think that's a helpful or effective way of approaching a debate, and I'm always disappointed when various MPs don't come up with alternatives as to how they could do things differently. And there is clearly much in the government's proposals that is sensible. But I cannot claim to be an expert on legal aid, and I've relied very heavily on the hard work of many other people in the course of this speech. I'm grateful for all of them for the work that they do to preserve what is good about the present system, for the wider struggle to provide access to justice for all, especially the most vulnerable. The case I've attempted to build has drawn on research and evidence done by others. And the same is true of the alternative I would like to offer the government. The Law Society, which was for so long officially responsible for legal aid, has continued to play a major role in shaping the debate around this important subject. They have produced an alternative set of proposals aiming to go beyond the savings the government has set out. Their savings are projected at £384 million and could even reach slightly more, but at the same time they claim to be able to protect the vulnerable people I have spoken so much about. I would suggest that the government is duty-bound to look very seriously at their proposals, and if they are workable, to adopt them. If the government really is serious about access to justice, it must listen to those who know what is needed to provide it. I look forward to hearing what other honourable members have to say and to hearing the Minister's response. I hope that he will signal a willingness to modify the proposals from those originally made in the light of the concerns that have been raised. Thank you.